No, well, thank you everyone for attending tonight. My name is Mary Ann Davies, and I am a supervising attorney here at the Disability Law Center, and I work in supervise our employment team. And we are really excited to have Bob Coursey here to talk about reasonable accommodations from an employer perspective, which I think this is a really wonderful and great opportunity to learn more about reasonable accommodations from a different perspective than what you usually get from us. And we are really excited to have Bob. Bob has been an employment lawyer for over 20 years. He spent the first 10 years of practice at Fisher Phillips, which is one of the most respected employment firms in the country. He then spent 11 years at the Employment Council, where he focused his practice on helping employers stay out of trouble through, putting in place good employment practices. And in 2021, Bob started his own company, Modern Age Employment Law, where he counsels, represents, and trains employers who are looking for a modern approach to their employment law and HR challenges. And we, not myself directly, but my colleagues have worked with Bob over the years, and it has always been a pleasure to work with him on different issues. He is, really dedicated to helping find solutions that work for the parties. And we've always appreciated his help to resolve issues. So I will turn it over to you, Bob.
Thank you, Mary Ann. And I really, really appreciate this opportunity. It's, I'm always thankful when I'm invited to talk somewhere, but I'm being completely sincere when I say this one is special, because I really love working with Disability Law Center. And as Mary Ann said, I've worked with this organization, I don't know exactly, but I think I'm going to guess 8 or so years in a couple of different capacities. In my previous job, when I was with a company called Employers Council, DLC is actually a client of Employers Council. So I would help DLC on their own employment issues. There's all kinds of things beyond disability that come up that I can certainly at least try to be helpful on. And then I've also had not Mary Ann, but some of Mary Ann's colleagues working on matters where we were opposing parties. And opposing is a harsh word. We were both representing parties and employee and companies who had differences regarding disability issues, ADA issues. I guess technically you would say that we were opposing parties, not in litigation, but just in trying to negotiate this. And as Mary Ann said, it was a pleasure to work with my Disability Law Center colleagues, if you will, during those negotiations, because it really is my philosophy, and I believe it's DLC's philosophy also, that issues like we're going to be talking about today shouldn't be adversarial. Sometimes they have to be, we all get that, but they shouldn't start that way. They don't always have to be. We should do everything we can to make them cooperative and solution oriented rather than conflict oriented. So it is really interesting, as I was preparing this presentation, in all my 24 years now of being an employment lawyer, I'm always counseling employers. That's all I've ever done. So I'm the one when an employee requests an accommodation, to use our topic of the night, the employer would call me and say, hey, we don't know what to do with this accommodation request. What is this ADA that we're talking about here? And I would try to help the employer, my client, understand the legal obligations, understand the options, and try to come up with a solution that was workable for everybody. But it was always from the employer's perspective. Now, I pride myself on not having an us versus them mentality, and really trying, like I said, to try to find solutions that are mutually advantageous. But in doing this, coming up with this presentation, I really had to get myself in the mindset of, okay, what if, because I'm assuming, and I hope this is correct, but I'm assuming most people listening to my voice right now or watching are coming at it from the employee or maybe applicant perspective, somebody who might be seeking an accommodation. So that is the mindset I tried to put myself in as I prepared this presentation. And thankfully, because I always have that in the back of my mind, even when I'm advising or counseling an employer, it wasn't that big of a jump. But it was an interesting sort of shift in perspective. I hope that I've been successful. There's no doubt I still come at this from 24 years of counseling employers. That is my perspective. But I hope that that perspective could actually be an interesting and useful perspective to bring to this audience. So with that said, let's jump in. ADA, no doubt, is a frustrating law. My job as an employment lawyer, ADA is a big part of it. It's not the only part. I deal with every employment law out there, and there are plenty of them. But if you ask any client of mine, what is the most challenging employment law to deal with? ADA will always be up there. It's going to be always top three. For some people, it'll be number one, but always top three. So I know how frustrating it can be from the employer's perspective. But I also absolutely know that it has got to be equally as frustrating, if not more, and probably scarier and maybe more emotionally difficult from the employee or applicant's perspective. So my goal at the end of our time together is that I can help you as an employee or applicant seeking an accommodation to, by taking away some of your employer's frustrations and fears maybe about the ADA, I want you to be able to get the accommodation that you're hoping to get and that we're going to assume for purposes of this talk that you are legally entitled to. So by helping your employer, we are trying to help you. So again, it's a win-win. That is my goal. This isn't about how to nail your employer or how to get your employer, in trouble or how to get the most damages from your employer. I want you to keep your job. I want you to love your job. I want your employer to want you to keep doing your job. So that's our goal. I think we are ready to proceed. The slide, please. Thank you. Thanks a lot. All right, here's what we're covering, and this is all sort of mixed up. I'm not going in top to bottom order here, but we're going to talk about how the ADA is challenging for employers. And then, as I said before, how can you make it less challenging for your employer? I'm not just talking in generalities. I want you, if you have a situation, that's why I highlighted you and I want to help you with your own situation, know how to best interact with your employer to get the accommodation that we want you to get. And then questions, please feel free to ask questions anytime. Ask them now, ask them throughout, ask them at the end. Just to remind you, we're here till 6 o'clock, which is about 50 minutes. So we have 50 minutes, 49 minutes or so. So if you have questions, either ask them throughout or make sure you fit them in before we get to the end. I also want to say at this beginning point, we are skipping over all the basics of the ADA. So what that means is for everything I talk about for the next 40-something minutes, I'm going to assume that we are talking about a qualified individual with an ADA recognized disability who is seeking a reasonable accommodation from an employer who has at least 15 employees. Almost every word I just said is legally significant. And if you don't know what all those words mean, that's okay, or what the legal definition of all those words mean, that's okay. But just know, I'm not going to be talking today about, do you have a disability or are you qualified for the job? I'm really focusing on the reasonable accommodation part of the ADA. Okay, let's move on with our slides here. All right, let's start off very generally. How is the ADA such a challenging law for employers? Let's back out just a little bit and very basic employment law. Well, everyone is probably aware of, we have EEO laws, equal employment opportunity laws, that in general, they prohibit discrimination in employment based on certain protected categories. Disability is one of those categories. There are many, many categories. You're familiar with many of them: race, sex, national origin, religion, age, lots of other ones. Like I say, disability is one of many protected categories. For almost all of those protected categories, the law is very clear, and it tells employers you are not allowed to discriminate based on protected categories. Or another way to put it is, you are not allowed to treat people differently based on the fact that they are in a protected category. Well, the ADA sort of flips that on its head. And so all the things that a good HR person or good company gets in their head, and we employment lawyers tell them, hey, treat people the same, be consistent, don't treat people differently. We sort of have to throw all that away when it comes to the ADA, because the ADA actually requires that we do pay attention to the fact that this person is in a protected category. They have a disability, and we actually do have to treat them differently. We have to treat them differently in as much as we have to engage in an interactive process to see if we can come up with a reasonable accommodation for them. That's not part of the law on the other protected categories. Now, quick aside, there are two other protected categories that also require accommodation. They are religion and pregnancy, at least here in Utah. We're not talking about those tonight, but the point remains, most discrimination laws tell employers do not take protected category into account, and certainly don't treat people differently based on a protected category. And then we have the ADA, which says, forget what we just said. Yes, pay attention to the fact that this person has a disability. And yes, you are going to treat them differently. You're going to treat them possibly better by giving them an accommodation. So that duty under the ADA is called the duty to provide a reasonable accommodation. So let's talk about that. Slide, please. So what we're going to talk about is specifically, like I said, the one part of the ADA that we have time to talk about, and I think that we can make the best use of our time, that we have time for the next 45 minutes now, is the interactive process. We're not going to talk about so many other elements of the ADA that are also challenging for employers. But let me say this, I think it might be interesting for this audience's perspective. There is so much going on behind the scenes that you may not know of when you make an accommodation request to an employer. And let me, even as I say that, I'm gonna give a caveat. I understand there are good employers out there and there are bad employers out there, and there's everything in between. I only will work with employers who are trying to do the right thing. Doesn't mean they're always going to get it right, because the law is challenging, but I'm not going to work with employers who are trying to evade the law. But I know they're out there. Believe me, I read cases about them, and it's terrible. I want you to know that although we're going to be talking about some of the frustrations that employers see, good employers, the ones that I'm spending hours on the phone with, there's all kinds of behind the scenes action going on that we don't have time for us to talk about in these next 45 minutes. But I want you guys to know you're only really seeing and a small part of the whole ADA process that goes on. A good employer, when they get an accommodation request, it sets off a chain of events that they take very seriously, and they're gonna go through a certain process, and you're gonna be a part of some of that, and you're gonna see some of that, but not all of it. That's just a quick little aside, so that you know that when we focus on the interactive process part of the ADA, that's not by any stretch of the imagination everything that's going on. There's a lot of it, like I say, that you don't really see. This is the part where you have the most input and where your actions can have the most consequence, for better or worse, on how the result turns out here. So let's go into that. Slide, please. I was pushing my arrow button on my laptop here, and then I remembered I'm not controlling it. Okay, so what is the interactive process? I said that's what we're going to focus on. The interactive process is a concept under the ADA where the employer and the employee, I mean, the words sort of are descriptive. They interact with each other through a process of sharing information, communicating, proposing accommodations, discussing accommodations, maybe proposing alternate accommodations. All of that stuff goes on with the ultimate goal, if you look at the final bullet point here, of identifying reasonable accommodations to help this disabled employee or applicant perform the essential functions of the job. So there's a lot to this slide or to this phrase interactive process, and I'm going to try to unpack some of it tonight. Let's go ahead and do that. Slide, please. So we said, what is the goal of the interactive process? The goal is to see if we can come up with a reasonable accommodation. Now, we could talk for hours about what are reasonable accommodations, what are not reasonable accommodations. I'm not going to do that with our time today, but just to sort of give us some context, these are some of the most common reasonable accommodations that I see requested and that I see courts or the EEOC or the Utah Labor Commission saying an employer almost always should grant. So I'll give you a few seconds to look at these before I move on. And by the way, this is maybe a good time for me to say any questions about anything I've said so far, including what any of these accommodations mean. And I will also say, by no stretch is this every accommodation. There is no limit to the accommodations. It is a totally open-ended concept. Creativity is encouraged. It's going to depend on the individual, the medical, the health condition, the job itself, all kinds of different factors. But the reason I put these up here, as I think I said, these are very common accommodations that I see requested and often granted. So I don't think I'm seeing any questions. So let's move on to now the next slide, just some common examples of accommodations that would not be considered reasonable. And again, this is not a full list. There's an endless list of requests that could be considered not reasonable accommodations, but these are some of the ones that I see requested and consistently shot down by employers, but more importantly, perhaps by courts and even by the EEOC, which tends to be very protective of employee rights. These are almost never going to be considered reasonable accommodations. Now, that doesn't mean, here's a little tip for you, doesn't mean you can't ask for these things. In fact, why not? It just means that the employer most likely is not going to be legally required to grant it. But I'm a big fan of it doesn't hurt to ask. So go ahead and ask for it. And if the employer says no, the worst that happens is you continued on the discussion to other possible options. All right, next slide, please.
I'm sorry, real quick. We have a question. It says,
Okay.
Can accommodations be amended if needed?
Yeah, that's a great question. I think I was going to touch on that towards the end here. I think if I'm understanding the question, which I heard as, can an accommodation be amended if needed? The answer is absolutely yes. If what the questioner means is, let's say an employer and an employee agree on an accommodation, but then it turns out either the employee or the employer doesn't feel like it's working out. It could be either one. Absolutely, it's that conversation should be restarted. And this is a good time to remind ourselves of what the phrase is again: interactive process. Both of those words are very meaningful. Process. It's not a one conversation thing. It's not one and done. So this is a great question to really illustrate one of the key concepts of the ADA's interactive process, which is it is a flexible concept. It is not rigid. Whoever asked the question, please let me know if I am understanding the question and if I answered it. But the answer would be yes, if either the employee decides, hey, this accommodation really isn't working for me, or if the employer decides, hey, we thought we could do this accommodation, but it turns out it's too much of a, we'll talk about this concept, undue hardship. The employer could say we can no longer do this accommodation. So questioner, if you wouldn't mind, let me know, did I get your question? I don't know if that was, I don't see a question in the chat, but I will assume until I hear otherwise that I answered the question. I'm happy to go back to it.
Yeah, sorry. It looks like they said that you did answer the question.
Okay, great. Thank you.
Thank you.
Yeah, sure. Okay, so with our focus on interactive process, I want to specifically talk about 3 areas where I see this breaking down, where I see so many of the situations that end in frustration and end in perhaps accommodations not being granted, so employees not being happy, or accommodations not being granted and employees seeking legal help, so that makes employers very unhappy. These are the 3 areas where I see most of the problems occurring in the interactive process. Ineffective communications, and that's a very broad category, rigid communications, and unhelpful medical information. So let's go into each one of these. Slide, please. We'll start with the first one, ineffective communications. The ADA is very clear that you do not have to use any magic language to make an ADA request for a reasonable accommodation. There's no word that you have to say. You don't have to say reasonable accommodation, disability, ADA. any of that stuff. And believe me, I have seen, and I'm sure my friends at DLC have seen so many cases where the employee thinks they made a request for an accommodation, but the employer didn't hear it that way. And that is a horrible way for any ADA situation to start. But it is a very, unfortunately, a very common way for ADA situations to start. And those are the kind that end up very quickly turning into legal messes. So my advice to you is, hey, it may not, the employer drops the ball on this a lot, believe me. And if I have any employers listening, by the way, train your supervisors, because it's usually the supervisor who is the person who is hearing that request for an accommodation or seeing something that should let the company know that there's a need for an accommodation. But if the supervisor doesn't recognize it and never tells anyone in the company, like HR or anyone else, nothing ever happens. That's bad. That's a bad thing. The employee doesn't get the help that the employee needs, and the employer now is probably facing some legal liability. So in speaking to you, who I'm assuming is mostly employee and applicant audience, dumb it down, make it easy for your employer. Take the issue of whether you made an accommodation request, take that off the table. And the way to do that is to just follow these steps. So please don't be ambiguous, don't be vague, don't make it mysterious, don't hide the ball. I don't know how many more ways I can say that, but make your request for an accommodation clear, make it in writing. Is that legally required? No, absolutely not. But does that mean you shouldn't do it? If you're asking me, I absolutely think you should do it in writing. One, it's going to force you to think more clearly. Two, it's going to take out any ambiguities and lack of communication that might come from an oral communication. And three, you know what? I almost hesitate to say this, being, trying to protect my employer clients, but if you ever end up in litigation, you're going to want that piece of paper showing on such and such date you made a request for an accommodation and your employer somehow fumbled it, didn't handle it correctly. So these are what I would say you do. Oh, I didn't finish the list. So put it in writing, explain how the impairment is affecting the job. You don't have to go into detail about your medical condition, but under the ADA, your employer has a right to know that you do have an ADA covered disability and that it is affecting your ability to do the job. So go ahead and share that information. Tell them how your condition is affecting your ability to do the job. And then propose the accommodation that you want. I'm going to put a pin in that because I also want you to be flexible on that. And I want to talk about that in a few minutes. But these are the clearest steps I can give you to have that process start on the best possible foot and take any argument by your employer that you never made a request or that they didn't understand your request. Take that off the table. So that's my advice there. Okay, ready to move on? So that was ineffective communications or lack of communication. Sometimes communications happen, but they're not really in the spirit of the ADA's interactive process. I don't remember if I used this phrase before, good faith, but the ADA expects both the employer and the employee to engage in that interactive process in good faith. That means they are both sincerely trying to reach a solution and a compromise that works for both of them. They're not trying to, hardball the other person. They're not trying to hide the facts. They're trying to be open and honest and productive and reach a solution. Sometimes that doesn't happen. And I often am the person who gets a call from these desperate and frustrated employers saying, we're trying to grant this accommodation. We want to understand this information, or we're trying to have a discussion with this employee, but they seem to be set on the one thing that they asked for, and they're not considering any alternatives. They're not looking at what we're saying, some of the hardships that we're facing or the health issues that we're facing, costs, etc. I am asking you, even if perhaps, maybe a court would tell you, you absolutely had a right to name your one accommodation and stand by it till the cows came home. And if your employer doesn't grant it, maybe the courts are ultimately in 5 years from now going to say you win. My advice for you is absolutely come in with the accommodation or accommodations that you want, absolutely start with those and ask for the moon. I don't mean be unreasonable, but ask for everything that you could possibly want. But please know that the interactive process may require you to be flexible, may require you to be open-minded. It's going to ask both parties to try to be creative where necessary. And it's also very important that you know this. The law is very clear that your employer doesn't have to grant you the exact accommodation that you requested. What the law requires, if you are a qualified individual with a disability, is the law requires that your employer grant you a reasonable accommodation that enables you to perform the essential functions of your job. Again, that was a lot of legal gobbledygook, so I don't want to get too tied up in that. But sometimes the employer may propose a different accommodation that would enable you to do your job, but maybe it's not the one you wanted. Those are tough situations, and one of those parties is going to either have to accept something they don't want to accept or take the chances that in litigation a court is going to rule against them. But it's important to know it's not automatically the accommodation that you request that your employer has to grant. Both sides should be flexible. Some tips I think that you should propose to your employer, and these are tips I propose to your employers when I get calls. These last 3 bullet points here, I love these ways to be creative when it comes to accommodations where the employer and the employee are having a hard time agreeing on something. They're both trying. I'm going to assume you're both trying in good faith, but you're really just struggling to come up with something that works. The employee is making a request, but the employer is very nervous that it's going to cause this concept of undue hardship, which the law says the employer doesn't have to grant your accommodation request if it's going to cause an undue hardship. Again, very legally significant and complicated term. But here's some ideas. Propose to your employer, say, hey, I understand you have concerns about this. What if we try it for a month or 90 days? I will show you that I think I can stay productive or hit my quota or do whatever it is. And if it turns out I can't, or if it turns out I'm not really performing the job, the essential functions of the job, or not performing the job satisfactorily, well, then we can talk about maybe a different accommodation. That's an idea I love, and it shows good faith by both sides. And what I really love about it is it actually gives the parties a chance to see in reality how that accommodation is going to play out, not hypothetically, because a lot of times employers are afraid to grant an accommodation because they think it's going to cause all these terrible things to happen. They don't know, but they think, and it might be a reasonable thing to think. Or flip side, the employee may say, this is going to work out wonderfully. I know this is going to cause no negative consequences to my productivity or performance at all. And sometimes those beliefs by the employer or employee turn out to be wrong. It turns out that it may be that hardship the employer thought was going to come to pass never comes to pass. Or maybe that perfect scenario, the employee thought I could get this accommodation and still, hit my numbers and be productive. Maybe the parties realize 30 days or 90 days in, it's not working out. So that trial period gives us great information to see if the accommodation is working. If it is, great. If it's not, we start again. We look for a new accommodation. That's sort of related to this next one, trial and error. Don't be discouraged if you try something and it doesn't work. Either it doesn't help the employee perform the essential functions, or it causes an undue hardship for the employer or some other problem. Keep trying. And I know it can be frustrating, but you have resources out there, including DLC, including lawyers like me, but also a great self-help resource. Let me tell you right here, if you have not heard of JAN, that stands for the Job Accommodation Network, and that's their website you see there. Awesome organization. Their whole reason for being is to help employers and employees come up with good, reasonable accommodation ideas. And you can enter it's a really awesome searchable website where you can enter the disability that you have. You can enter the job that you have. You can enter like different accommodations like interpreter or seeing eye dog or, whatever, and search it in all these different ways. So I highly encourage you, if you want to go in equipped with some ideas to propose to your employer, Jan could be a great resource. And you can also invite your employer to get on it. I've even heard, now that I'm thinking about this, I've heard of, and I encourage this, employer and employee sitting down in front of the computer together, or I guess in the COVID era, sharing screen like we're doing right now, and going to Ask Jan together and having that interactive process with Jan on the screen and going through and looking for accommodations. I love that idea. Those are parties who are truly in good faith engaging in the interactive process. Okay, let's move on away from, still on rigid communications. This is something that I hardly ever hear talked about, and I'm not surprised because it's rare that it would, I think, probably be a solution, but it's out there. So I wanted to talk about it since I'm trying to talk to this audience as employees or applicants who are wanting an accommodation. Here's some information that a lot of people just forget to share. If your employer tells you that they can't provide the accommodation you want because of undue hardship, and it's a financial undue hardship, meaning they just cannot afford it. There's a couple different things, and you don't start with these things. These are once that process is close to breaking down and the employer has basically said, we cannot afford that would be an undue hardship where we probably cannot grant that accommodation. Here's some ideas for you to throw out as an effort to save this accommodation. Is there a vocational rehab agency around? We have some agencies like that here in Utah. I don't know offhand if they provide funding. Maybe some of my DLC friends know offhand. I'm thinking of, oh gosh, I can't think of their name right now, but there's hearing impaired, there's a vision impaired agency. But anyway, there might be funding available from an agency that helps people with whatever your health, your disability condition is. There could be tax credits. I don't know if there are. You don't probably know offhand, but talking to, again, I'd invite the DLC, my friends here at DLC, if you know of resources on any of the first two bullet points here, if that's something you point people to, I'd love you to chime in, or even just let me know that you have recommended those. And then finally, and this truly is, as I say here, a last resort, never go in offering your own money. But if the employer says, we cannot afford this accommodation, and this is a big if that is a legitimate statement by that employer, if the law would actually say, yeah, it's true, this employer, they really can't afford this. As a last resort, you could offer to pay some of whatever the accommodation, pay for all of it, pay for half of it, pay for any portion of it. That's an option that's out there, but please, like I say, don't start with that one. That's a last resort. And the obligation to pay for the accommodation is absolutely on your employer unless it's an undue hardship and they don't have to provide the accommodation. Okay.
And Bob, just to chime in, Utah does have its own vocational rehabilitation agency that you can find through the State Office of Rehabilitation. And then also, as you were mentioning, we have services through the state for the blind and visually impaired. We certainly have had clients who have been able to secure funding through vocational rehab, which I think is a really great resource. I think the only sticking point we've ever had with Voc Rehab is when they want to provide a job coach and the employer's not exactly sure about having a third party come in. But for the most part, the Voc Rehab can be a really helpful resource.
Yeah. Now that reminds me, just as you mentioned that issue about the third party coming in, that's actually something that I worked on when I mentioned earlier a case with the DLC. With one of your colleagues. That was one of the issues we were talking about. So anyway, thank you, Mary Ann, for chiming in on that. I think that's all for here. Okay, let's move on to the last interactive process challenge I want to talk about, which is medical information, or specifically unhelpful medical information. This is one, boy, I could talk, this is a pet issue of mine. any employer who's ever requested medical information to support an ADA accommodation has probably had some frustrations with the information they got back. So let's talk about this, because this is where a lot of the problems in the interactive process happen, and where a lot of the breakdowns happen in that whole seeking out of the accommodation. First off, it's really important that you all understand, and I know this isn't necessarily a comfortable concept, but when you make a request for an ADA accommodation in the workplace, by doing that, you are waiving the confidentiality of certain medical information, not your entire medical file, not even most of your medical file, but to the extent that your employer might, and I would say should, ask you to provide certain medical information from a healthcare provider. If you want that accommodation, you have to provide that medical information. That's just built into the deal. So just know, if for some reason you want to keep your health medical information 100% private, you do not want to share anything with your employer, well, then you're really making it hard and perhaps impossible for you to get any accommodation under the ADA. I'm not going to say impossible, because some accommodations are so obviously needed and so easy to provide that an employer really shouldn't be requesting medical information from you. But for the most part, I'll just tell you, when clients call me and say, we have a request from this employee for a reasonable accommodation, first I'll say, is it obvious? Are they in a wheelchair and they want an office on the first floor instead of the second floor? Is that easy to do? Okay, we're not going to request medical information in that situation. But those don't tend to be most of the situations that I get calls about. So almost always I will advise my clients to ask you, assuming that's you, my audience here, to provide medical information. And like I say, you don't have to provide the medical information, but if you don't, you're probably giving up your right to get any kind of ADA accommodation. So please cooperate. Your employer has a right to ask for that information. Cooperate with it. It's in your best interest to cooperate quickly and fully, and make the process go as smoothly as you can.
Quick question. Sorry to interrupt.
Yeah,
I have a quick question from someone.
Yeah, let me do this. Let me just hit these last 2 bullet points and then come back to the question, and there maybe even be more questions after that. Your employer should, if they're listening to a good lawyer, should give you some kind of reasonable deadline to give that medical information to them. The ADA doesn't tell us how long. I usually recommend at least 15 days that they give you. If you need more time, tell them why. Say, my doctor is out of the country, or my doctor is booked for 3 weeks. But if your employer gives you a deadline, do everything you can to meet the deadline. If for some reason you can't, let your employer know as soon as you can. This is all, in a way, just common courtesy. When someone asks you to do something by a deadline, try to meet the deadline, but don't just miss it without letting them know what's going on. I always recommend to my clients that if somebody asks for an extension, you give it to them. And in fact, I often counsel my clients to give multiple extensions, as long as the employee is making good faith efforts to get this medical information. I want my employer to keep trying also. Also, when you talk to your healthcare provider, please be honest with them about your condition and how it relates to your job. A lot of times what happens is, and this isn't necessarily the employee's fault, but the healthcare provider is going to take whatever the employee says and believe them 100%. And if the employee says, I think I need a year off of work and, a corner office and a company car, and, I'm just making stuff up, but a list of crazy accommodation requests, the healthcare provider will often request that because that's what the patient/employee is asking for. You can take that. That's one approach you can take. I will tell you that when the employer gets medical certifications back like that, it usually just ends up causing them confusion and frustration. And then the employer has to push back, sometimes requesting more information or clarification from the doctor, sometimes just deciding we don't this is, risky for an employer to do, but the employer doesn't have to go with what the doctor says. Usually they should, and usually they do, but if the employer just thinks the doctor totally missed the ball here, the employer could ignore that doctor information and maybe require you to go to a different doctor. So my advice to you is skip the exaggerations, and I know that happens, believe me, and just be straight with your healthcare provider. And again, go into that medical appointment with the idea of, I'm not trying to pull a fast one on my employer. I'm trying to, in good faith, come up with solutions that can help me do my job and also help my employer, get the work done. So that's, again, we could go into all kinds of more information. This is such a crucial place. And I will leave you with this thought on this, and I am going to come to those questions. As much as you may be frustrated by your healthcare provider that they can't get you information quickly, or they're not willing to fill out your form, or they're going to charge you, $100 to fill out your form, we can have sympathy for all that, but it's so crucial for you to know that it is ultimately 100% your responsibility to get that medical information to your employer if your employer asks for it. It's not, you are not off the hook if your doctor, your healthcare provider somehow blows it. If they miss deadlines, if they go silent for a month, that's all your responsibility. So it's frustrating. I guess the only thing you can do there is, like I said before, let your employer know you're trying, and you may even have to get a different healthcare provider involved. Okay, I had at least one question. What were they? Are they written out here?
Yeah, so one of them is in the Q&A. So someone asks, who actually gets access to this? So I'm guessing the medical records.
Okay, yeah, I'm looking at it. Yeah.
It says just HR, yeah, or does it include management and such? I work at Intermountain Healthcare for reference.
Yeah, great question, Ray, I think. The ADA says all of this information about your request for an accommodation, all the medical information, everything really about the whole discussion is considered protected, confidential medical information under the ADA, and an employer absolutely has an obligation to keep it confidential. And that means it has to be kept separately in a separate file, has to be marked confidential, and it has to be kept either physically under lock and key or electronically, in the lock and key equivalent. Who gets it? HR for sure gets it. And then as far as management, it's really on a need to know basis. And that is a incredibly small group. Sometimes the immediate supervisor may need to have some of this information. And let me clarify, not the underlying medical information. No one other than HR should ever see the underlying medical information. But as far as the discussions and the accommodation discussion and the interactive process documentation, a supervisor may, and I'd say often is, involved in those discussions. And you sometimes have to share with the supervisor, HR may have to share with the supervisor, hey, Supervisor Mary, your employee has a condition, an ADA covered condition, and we are going to talk about providing reasonable accommodations. There's no reason in almost any situation I can think of that the supervisor needs to know the actual health information. So again, please let me know if I answered that question. If not, I'm happy to continue. Were there any other questions?
It looks like there's two more in the chat.
Oh, in the chat. I'll go ahead and pull those up then. Okay, can the request for medical information come in the form of a letter from doctor on letterhead from provider? Can the request for, oh, I just lost it. Can the request for medical information come in the form of a letter from the doctor? I think I understand what you're saying here. So the ADA doesn't tell employers or employees the format of the medical information or healthcare information that an employer has a right to get. So there's not a form like under the FMLA. A lot of you guys may know there's a specific form that you can fill out that the Department of Labor publishes that we can use. We don't have something like that with the ADA. Let me tell you so that's the law. There is no specific form. If the employer wants to accept a letter from a doctor, I mean, let me even back up. Remember, the employer doesn't have to request medical information. Almost always, I would recommend they do. Sometimes, if they want to be very lenient and request a very vague letter from a doctor, they can. I don't ever, I shouldn't say never, I would very rarely counsel one of my clients to accept a vague, 2 or 3 sentence letter from a doctor saying, my employee has such and such condition, please excuse them, from performing this duty for the next 3 weeks. That, to me, that does not give the employer the information it has a legal right to under the ADA. So I always recommend to my employers, if it's worth seeking medical information, use a specific form that asks all the right questions and all the questions that we have a right to consider to give us the best and most information to make the right decision here. So again, please let me know if that was the question, and if so, if I answered it. And then Aaron asks, in cases when the employee isn't communicative after submitting their initial accommodation request, how much time do you find is reasonable for them to obtain and submit sufficient medical information before ceasing their request? I give them 14 calendar days, and I'm just wondering if that's standard. If they seek an extension, I always grant one. I think I'm on the same page as you here, Aaron. Remember, ADA is very fluid. It's very flexible. Again, I'll contrast it with the FMLA, which has strict deadlines, 15 days, 5 days, things like that. Every situation, I wouldn't give the same, I wouldn't give a one answer that I just say, tell clients, okay, now go apply that in every situation. But I will tell you in general, I give the employee my first, I give them the deadline, 15 days. That's almost always my default for my first, give us the medical information in 15 days. And just as a tip, I will actually get out my calendar, count out 15 days, and tell the employee that means on May 15th or whatever. If the employee misses that deadline, I would give them typically an extension of, and it's going to change depending on why they missed the deadline, probably a minimum of, well, if they say, hey, I just need 3 more days, well, then that's what I'll give them. But I'll usually give them anywhere from 7 to 10 days as an extension. And then typically I will shorten the extensions as we go out. So this is not set in stone, but it might look like this. Initial deadline, 15 days. You missed that one? Okay, we're giving you a second chance, 10 days. Give us back to it in 10 days. You missed that one with some indication that you're trying. Okay, we're going to give you 7 days. And then if they really have a good reason, I really feel like they're trying, but they still haven't made it, I might give them one final extension. I don't know what we're up to yet. Not quite a month, I don't think, but pushing it. That is a timeline I would often recommend. And if any of you are thinking from the employer's perspective, that's got to be frustrating. You're right. But I tell employers, you want to be the one who looks like you bent over backwards in this process. And you know what? Now that I'm talking to a different audience that I assume is mostly employees, I'll say the same thing to you. You want to look like, if this process does break down, you want to be the person who looks like you were bending over backwards to keep the process moving along. You didn't drop the ball. If you needed more time, you expressed that, So long story short, a lot of different timelines, but I think I answered that question. And then Ray, okay, I think we're good on questions. Did I miss any? I think we're good. If we're good, let's move on. We're coming up on our end here. All right, yeah. Great timing, and please keep the questions coming. So anyway, this is, like I said, we've just talked about the interactive process. Why did I pick this to talk about? Because it's the part that you have the biggest role in. A lot of the stuff that happens with your ADA accommodation requests are happening behind the scenes. It's happening in HR. It's happening on the phone with me. You don't have a lot of control over a lot of that, but the interactive process is half you, or at least it should be half you. So here are my takeaways for you guys. And by the way, if you're an employer or HR person listening, all these tips, you just flip them around and they're probably equally applicable. So go overboard in fulfilling your end of the interactive process. That's what I was just saying. When these things get ugly and they go to court, it's often the party who really tried harder in the interactive process who wins the litigation. Next tip, follow your company's policy on requesting ADA accommodations. That should be your starting point as to the procedure itself. Most companies these days have an employee handbook. If you have an employee handbook, there's going to be a policy in there. It's going to be called different things. It might be called equal employment opportunity. It might be called anti-discrimination or discrimination or something like that. Could even be called specifically ADA or accommodation. Look for the policy that is something like that. And it should, a good one will have in there specific instructions for what to do if you need an accommodation. Usually it's going to say something like contact, tell your supervisor or tell your department head, or often go straight to HR on these issues. So start there. If your company doesn't have a policy, or if the policy is just not at all helpful, and if you have HR, that's your contact person. I would suggest to you that as much as it might be nice to just tell your supervisor, because maybe you see your supervisor every day, maybe you're friends with your supervisor. If your supervisor is not trained to know what to do with your request, that's very risky for both you and the company. So I would say make sure that your request goes to HR and that you get it there directly. Quick note here, even after, hopefully everyone did their job, their interactive process right. We grant an accommodation, but sometimes even after the accommodation is granted, it's not really working. So note that this is a process. As we said, it's ongoing. So if something is happening and the accommodation just really isn't working, let HR know. Or if your circumstances change and you needed a different accommodation or an additional accommodation, or actually, be honest, if you don't need the accommodation anymore, show your good faith by saying, hey, I don't need this accommodation anymore. And then 3 words that kept coming up to me that sort of summarize all this. For you, if you want the accommodation that you're entitled to, communicate with your employer, educate your employer, and cooperate with your employer. And with that said, I am done, but happy to take questions until 6 o'clock.
Yeah, and Bob, I just want to say thank you. I thought you had so many really wonderful practical tips. The piece about looking at a trial period for reasonable accommodations, I think it's just so smart and something that I will be using going forward. I think it goes both ways for employers who may be a little shy, but also employees who aren't exactly sure about the offered accommodation. So I think that's such a smart, practical tip. And I would just also really echo your comments on the medical information. You can certainly have your doctor write a letter. I generally find from a plaintiff's perspective that those letters are really bad and they're not usually very helpful to you. So when you're working with your medical provider, it is, even if there's not a standard form your employer has, I think it's really pivotal to make sure that it's clear about explaining, what part of your job you're struggling with, how, you need an accommodation and how that would allow you to perform the central functions of your job. I would agree those 1 to 2 sentence letters from medical providers aren't very helpful at all.
I'm glad to hear you say that too, that they don't help you. They don't help anybody. They're just, I understand it's easy to get that. And the doctors are so busy. I can imagine doctors roll their eyes when they get these 4-page forms, but that's we're asking them to do that. And that is, again, I'm glad to hear that you say that's preferable from your perspective also.
Yeah, absolutely. Yeah. Having had a few cases that went to litigation over that involved weird doctor's letters, I can tell you I really prefer a straightforward letter from a medical provider that's clear about why you need the accommodation and how it will help. So
yeah,
but no, we just, we really thank you for your time. We certainly do have a few minutes for questions if anybody has them. We will post this on our website, and just really appreciate everyone coming tonight, and just thank you so much. Oh, it looks like we do have a question.
What happens if the employer thinks an accommodation is unreasonable, but the employee disagrees? Oh gosh. Well, then you have Mary Ann and me having a conversation, I guess, and trying to work things out. There's no easy answer to that, because that is what so much, that's what so many of these cases that we read about are about. Let's see, but rather than just leaving it at that very unhelpful answer, let me see if I can give any practical. So the employer thinks it's unreasonable, which happens all the time. The employee disagrees. You know what? I know this is not real helpful, but you just have to have that communication. Oh, in regards to scheduling in specific. Oh, that's more interesting, because scheduling is one of those things that, that's objective. It's numbers. It's a clock. It's 9 o'clock or it's not 9 o'clock. I will tell you, as far as running the company's business and what is a reasonable schedule, and when employees need to be at their jobs, the courts will defer to employers on that. If an employer says, look, our busiest time of day is between 12 and 4 o'clock, and that's when we need to be fully staffed, well, the courts will defer to that. Now, that said, if the employee can refute that, again, that's where we have thousands and thousands of lawsuits. So all I can say, and this is obviously not specific legal advice, is try to have a good faith communication, a conversation with your employer. Make sure you're both really understanding each other's perspective. And that sounds simplistic, but I swear, the older I get, the more I'm realizing that just doesn't apply to this. It applies to so many things in life. Is making sure before you start arguing, making sure you both really understand where you're coming from. The employer might know something the employee doesn't know, or maybe the other way around. Maybe the employee says, no, you think that's our busiest time of day. I'm telling you, for the last 6 months, we're slow from whatever. Trying to come up with an example, but that's about the best I can do. But those are just tough situations, and sometimes they end up in lawsuits. I guess that's the sad reality. Marianne, do you have any awesome words of wisdom for something like that?
Yeah, I mean, I think one thing in terms of, if you're in a place where somebody has said, this is unreasonable. I mean, I think there's a couple things. I think from the employer's perspective, I think one thing that's really difficult for employees is when an employer denies a reasonable accommodation on the basis of an undue burden without giving an adequate explanation as to why. Sometimes you will get that form letter that just says this is denied as, because it's an undue burden, and then that leaves a lot of questions. Sometimes I end up in situations where I end up talking to opposing counsel, and then I'm able to understand why and communicate that to my client. But, like you said, Bob, I think it's better to do that on the front end and have that real back and forth. I also think too, this also goes back to, engaging in this interactive process of, if an employer says, look, it's unreasonable for these reasons, then really, there is this still ongoing obligation to talk about alternatives. So I think kind of saying, in that moment, you could always say, can you explain to me why this isn't an undue burden if you're the employee? And, if they lay out their answers for you, you can instead pivot and say, hey, I would like to discuss some alternatives then. So, it's not a perfect process, but it is one that involves, good communication back and forth from both the employee and employer.
I'd be curious to know why, and I think that's still Ray, and I'm sorry if I'm mispronouncing your name, why you're nervous to ask about an accommodation. And that might be getting into more too personal, but if your company has HR and they're even decent HR, they should fully be prepared and capable to have a conversation like this. And it should not at all, by law, it should not negatively affect you at all. The law specifically says you cannot be retaliated against in any way for seeking an accommodation, whether they grant it or not. So that's important for you to know. You are legally protected, and any good company, and I know that, like I said, they're not all good, any good company will not hold it against you that you requested an accommodation, even if they can't grant it. But I don't know your specific situation. That might be, if you have some specific reason to be concerned, I would maybe talk to a lawyer, maybe talk to DLC about that. Yeah, because you shouldn't be. I get it. No, it's not a fun conversation to have, and in that sense, I get being nervous. But you should not be fearful in any way for your job.
Yeah, absolutely. I mean, I think that's very good advice. And I think it goes back to, so much that you talked about, Bob, in terms of just making sure that what you're asking for is clear, that you're going in ready to have kind of a more fulsome conversation, making requests in writing, and um, if all else fails, you can always request reassignment if something's an undue burden for your job. So reassignment is where you ask to be put in a different position. So if something is an undue burden for your current position and you also work for a large employer, you could ask for reassignment to a different position that could accommodate your disability.
Yeah, great point. Thanks for the questions. All of those were great questions that I think really added to the conversation. And I'm happy if there was any lingering questions, I'm happy to stick around.
Yeah, thank you again, Bob. Like I said, I just thought your advice was so practical and really helpful. And I definitely picked up a few tips, and I just think that the tip about doing a trial period is such a good one. I don't know why I haven't thought of that before, but that is a wonderful idea.
Good.
So,
Yeah, I'm glad. Well, hopefully that was helpful, everybody. Thank you.
yeah, thank you.
All right. Bye, everybody.